We are pleased to welcome Ambassador Marc Perrin de Brichambaut, who is going to talk about his work on the International Criminal Court in The Hague. Judge de Brichambaut came to us because Marc and his lovely wife Sheila, who's also here, she's a Canadian diplomat, we all served together in Vienna, Austria in the 90s. And so it's a special treat for me to see them here again and to be so pleased that they chose to come to Springfield, which is my new hometown. So Marc graduated in 1948. And please, those of you that are French speakers, I'm not a French speaker, so I'm sure I'm going to butcher this. From the École Normale Supérieure Saint Cloud and the École Nationale d'Administration, where he joined the, Conseil d'État. Is that close? No, okay. Which is the Supreme Court of France. Marc, as you can tell, is an attorney, a diplomat, and a judge. He was appointed the Conseiller d'État in 1992. He also served in numerous senior positions in the French Ministry of Foreign Affairs and the Ministry of Defense of France and in the United Nations Secretariat. As legal advisor to the Foreign Ministry, he led the French delegation to the Rome Conference and signed the Rome Statute on behalf of his country. And that's a big deal, guys. That's a big deal. We're so proud of him. He also served as the Secretary General of the Organization for Security and Cooperation in Europe, the OSCE, from 2005 to 2011. He's taught extensively international law in the Sciences Po in Paris, and he was elected judge of the International Criminal Court in 2015 for a term of 9 years from the group of Western European and Others Group, List B. And that's a very complicated and important process. And so for Marc to be elected, that's another big deal. So I'm so proud to have Marc and Sheila with us tonight. And Marc will speak for approximately 40 minutes. And at the end of that time, he's very willing to answer questions. And I will be your moderator for that segment. So Marc, without further delay, welcome. And thank you so much for agreeing to speak with us tonight.
Well, good evening to all. It's a great pleasure to be here with you tonight. So Katie told all about you. I was, of course, not graduated in 1948. This is when I was born. This is the only correction I would make.
Did I say that?
Yes, you did. And the other correction I have to make is that in this lead slide, we are the 26th and not the 28th. But just to give you an idea of what the picture is on top of the slide, this is the seat of the International Criminal Court in The Hague, and the main tower is the courtrooms. We have 3 courtrooms. On the right, you have the tower of the judges, and on the left, you have the 2 towers of the office of the prosecutor. This is to give you not the impression of the power or majesty, but of the modesty. This is a work in progress, and this is what I would like to try and describe to you today. There has been 75 years of progress on the way to building an international criminal justice system, and a number of tests and experiences. Actually, the first one, the one with which I plan to start, which were the Nuremberg trials, was probably the most successful. It's proving extremely difficult to replicate the achievements of Nuremberg in the current period. So as you know, the 20th century was a period of great turmoil, but also of a progressive awakening of a global conscience. Major crimes which were committed on the occasion of conflicts cannot go unpunished. This was a lesson that was progressively learned over the wars of the 20th century. And the impunity of the individuals who are responsible for those crimes cannot be tolerated. This seems obvious. It is a very steep thing to achieve, and we are only moving fairly slowly along that road. President Wilson made sure that in the Versailles Treaty there was a provision providing for the prosecution of the Kaiser by an international tribunal. So first, American involvement in the idea of having a group of nations take responsibility for the prosecutions of crimes committed in the context of a conflict. Of course, the second major American involvement, starting in 1942, it was when President Roosevelt promoted the creation of an international tribunal that would bring to justice the leadership of the Third Reich, and that fostered an agreement in August of 1944, creating the framework from which the Nuremberg trials would emerge altogether. A second direct American involvement at the very top in support of this idea. During the 1990s, the next step, I'm going to come back to Nuremberg, but just to give you a sense of perspective, the next step of the international criminal justice was the creation of the so-called ad hoc tribunals, which were created by the Security Council of the United Nations following crimes committed in former Yugoslavia and in Rwanda. And this was also, to a large extent, an American initiative adopted, of course, with the support of the 5 permanent members of the Security Council. When this institution came to be created, the US was a very active participant in the negotiation. And I can tell you that Ambassador David Sheffer, which was then the head of the US delegation, tried his very, very best to get a deal that could be brought over here to the Senate and had a chance of being ratified. There was a delegation in the back of the American delegation that came from Senator Helms, and that was less convinced that this was a good idea. So we will come back to those episodes altogether. So this institution does not have currently U.S. membership. Also, the U.S. is very much involved in the way it works. So at each of the steps of setting up a system of international criminal justice, the U.S. played an important role, made major contributions, but there have also been moments where it took its distance, certainly during the Bush presidency and to a certain extent even more during the Trump presidency. We are now in a different phase. And actually, I could quote it, but there is a resolution that has been tabled by Senator Lindsey Graham in the Foreign Relations Committee of the Senate that actually directly calls for the involvement of the International Criminal Court in prosecuting crimes which may have been committed in Ukraine and names Russia. I will not be speaking about Russia. As a judge, I have to be extremely careful about whatever cases I may have to deal with at a later stage. But occasionally you will understand what I'm referring to, I'm pretty sure. So with your permission, in order to clarify what are the conditions for the work and for the success of the national tribunals, and after all, we only have 75 years of trajectory to draw those lessons, I will take a bit of a historic approach and start with Nuremberg. So this is a view of the judges at the International Military Tribunal in Nuremberg in 1946. And the Nuremberg trials were not obvious. They were the result of a strong political project and strong political push which basically came from President Roosevelt and was followed up by President Truman. And the idea was that after a devastating war, the major powers had to agree that the leadership of the Reich, which had initiated that war, should be held accountable for their criminal acts. And they therefore used this political determination to convince the other key allies, but also 17 other nations, to set up a full court of justice with prosecutors, judges, defense counsels, the first use of simultaneous interpretation for this sort of exercise. And you see here the Soviet Union flag, the British flag, the American flag, the French flag. Each had 2 judges and each had 2 prosecutors altogether. What was absolutely new in Nuremberg was the idea that the crimes were identified for the first time, the crimes over which the court has jurisdiction. These were the crime against peace, war crimes, and crimes against humanity. And to show you the irony of the situation, I'm going to read you, with your permission, the definition of the crime against peace, which is a crime of aggression. And this definition was worked upon by the lawyers, basically of the Soviet Union at that time. You will understand the irony of the situation. The crime of aggression was defined by them as to initiate a war of aggression, therefore, is not only an international crime. It is a supreme international crime, differing only from the other war crimes in that it contains within itself the accumulated evil of the whole. Quite a message. So the trials lasted for 8 months, and the key force behind those trials was Robert Jackson. Robert Jackson was the architect of the prosecution. He'd been a Supreme Court judge appointed by President Roosevelt. He read the initial indictment, followed by others. But what is important in this picture is, if you allow me, is not only the personality of Robert Jackson, it's everybody who was behind. He had with him a magnificent team of lawyers, which worked very hard to put together the different cases, and who had full access to an enormous amount of evidence. They had all the files which were available in the system of the Reich. So they had no problem in accumulating those evidence. They brought over witnesses which were presented their experience in front of the tribunals. So here you see for the first time almost the ideal format of international justice, because the 15 accused, I'm sorry I don't have all the pictures, but were across from the judges. It was a small group, but it was the key survivors of the leadership of the Reich. There were the clear definition of the crimes, clear machinery, and full access to witnesses of evidence without any restrictions. And this is almost chemically pure, what an international tribunal should be. This experience has never been replicated, and further events were not as satisfactory for obvious reasons. But nevertheless, the legacy of the Nuremberg trials was first a set of legal principles which are called the Nuremberg Principles, which encapsulate all the key elements of international justice. The Genocide Convention, which was adopted and is practically universal soon after, and the Geneva Conventions and Protocols, which were, if I may say, in the wake of the achievements of Nuremberg. As you all know, the period following the late 40s was not a good period for international cooperation. So the thrust of creating a permanent international criminal court, which was explicitly mentioned in the Genocide Convention, was sort of went on the back burner for quite a few years. And it is only in 1990, when we started working together with Caddy, that the context, the convergence of interest within the international community was strong enough to have, again, the idea of having prosecutions against major criminals of war crimes and fighting impunity. And of course, this period was a period of international convergence, where the P5 members were working together effectively, but it was also a period where there were many crises. And therefore, the two major experiences of the period were creations of United States Security Council, which, as I mentioned, and with the encouragement and the initiative of both the Western Europeans and the US, created two ad hoc tribunals to prosecute the main culprits of crimes committed in former Yugoslavia and in Rwanda. Advantage of the being created by a Chapter 7 resolution of the Security Council, you have the full force of the Security Council behind you. It's mandatory, all states have to obey. On top of it, there was a NATO force on the ground, certainly in Bosnia, which normally would have helped to get the accused into the dock. Unfortunately, they escaped for quite a long time, and both tribunals had a very difficult time to get started. They only got the Milosevic's, the Karadzic, the Mladic, approximately 10 years after the creation of the tribunal. So the existence of the tribunal, the ICTY, did not deter the criminals to continue to do their thing to a certain extent. And in Rwanda, the Rwandese authority made sure that only the one side, which had been involved in crimes, were effectively prosecuted, and they made sure that another side had nothing to worry about. Experience, a very important one, because this created a practice, a culture, a group of international lawyers. It was not judges from 4 countries. It was judges which came from all over the world. And even now there is still something called the MICT, which is a mechanism in The Hague, which is finishing the last trials initiated by the ICTY and the ICTR. And there is American judge, Chinese judge, Russian judge, and judge from all over the world. So there is still a universal focused on a few two areas, process of international justice working. The heritage of Nuremberg was involved in the Security Council resolutions, i.e. the definition of the crimes, crimes against humanity, war crimes, genocide, not aggression there. But still, progressively those legal tools, as well as the modes of liability, have become codified. There is a jurisprudence. So there is an international core collection of good practices and legal definitions that exists, that is the emergence of this period. And as a culmination of this exceptional period, where you had this convergence within the international community on the need for justice, on the need for the promotion of human rights, you had throughout the second half of the 90s this process of preparing for a permanent international tribunal, which would be universal and would be available as the diamond of human rights in prosecuting major crimes. And this led to the Rome Conference in June, July of '98, and to the adoption of the Rome Statute. That's where, of course, things become a little more complicated because states when it was for a specific situation or a specific set of potential criminals, that was all right. But when it became the possibility of having any of your citizens prosecuted by an international tribunal without necessarily the agreement of your judges or of your political authorities, a number of countries started to raise eyebrows. And they wanted to protect their sovereignty. They wanted to assert the primacy of their own courts, to make sure that foreign judges would not overrule them. And therefore, they wanted to make sure that whenever the soldiers would be deployed abroad, whatever might happen, those soldiers wouldn't get in trouble. So it was a very difficult negotiation altogether. The P5 members had their own interests. There were other groups called like-minded, which wanted a much more ambitious system with a very strong international prosecutor. And what came out and what I'm going to describe to you is really a compromise between national sovereignty, the responsibility of national courts, and what international judges can do or not do. So it might be a bit technical, but this is the practice of the world we live in. It's still a world of nations. It's a world where national sovereignty counts very much. The choice of the French delegation, because we got a special article that allowed the nations to claim that their nationals could not be prosecuted for 7 years for war crimes. This was what the French president had put in my instructions, and he wanted to make sure that French peacekeepers deployed abroad would not get and be under the jurisdiction of this court. So we managed to get this article, which is quite special, I must confess, from a purely legal point of view. But Ambassador Schäfer didn't manage to get his amendments to the statute adopted when there was a vote. So the U.S. did not participate. And albeit President Clinton, I think, in the last days of his presidency, signed the Rome Statute, they were immediately unsigned by his successor. So the U.S. is on the margins of the Rome Statute. Briefly, the main characteristic of the Rome Statute system. First, it is an international treaty. 124 nations have signed. Most of the African nations, practically all the Western and Eastern European, all the big Asian democracies, and all the Latin Americans. Those who have not signed and ratified: Russia, China, India, Turkey, Israel, US, most of the smaller Asian countries. Second, I will elaborate further. It only works in a complementary way with international systems. The core of the Rome Statute is to say the responsibility of prosecuting major crimes lies with national tribunals. It is only when the national tribunals do not do their job that the international prosecutor can start getting involved. And we're going to return to this. The specific crimes, heritage of Nuremberg and the ad hoc tribunals, war crimes, crimes against humanity, genocide, and aggression. It was only formally entered into force in 2010, and it's only for those countries who are willing to follow it. None of the major countries, including France, to be precise, has ratified the amendments concerning aggression. Maybe they have their reasons. It's not for me to say now. I'm not in that business. And of course, it's not against organizations, it's against individuals. So the prosecutor he can first identify a situation where crimes have been committed, but after that, he has to put together cases against individuals, which, like in any normal criminal system, involves having evidence, having witnesses, having put together the modes of liability you're going to prosecute the person for, and having, that's a very important of the Rome Statute, the accused has to be present. So he has to be arrested. You understand what all this means. This means that practically the prosecutor depends on states. he can only, we will see under what conditions he can go after individuals, but he can only investigate, he can only gather evidence, gather witnesses, if he's allowed by states to go on their territory or to cooperate with him in order to do things. Because I know that you have a you situation in your mind. This is why I'm laying the framework for all this. And for the current challenge, all these conditions will have to be met one way or another. So just, sorry, I'm trying not to make it a didactic PowerPoint, but complementarity is so important that I thought that you might want to read this, because it's the key element of the system set up by the Rome Statute. The preamble says, recalling that it is the duty of every state to exercise its criminal jurisdiction over those responsible for international crimes. So this is not as simple as it looks, because it means that each state has to incorporate in its own legal system those crimes, that each state has to have dedicated units within its judicial system that can be specialized in investigating and prosecuting those crimes, that it has to have judges that are trained in those particular set of crimes. It's not something that operates easily and spontaneously. So if the prosecutor of the International Criminal Court at a given moment identifies crimes on which it believes the court has jurisdiction, but which have not been properly investigated, prosecuted, or adjudicated by a country, it can go to that country and say, to that state, and say, look, there's something wrong which we are worried about. We are opening a preliminary examination on you. That's an encouragement to a sort of dialogue with that state for them to do better in terms of doing their own homework. And if at a certain moment the prosecutor says they've not done enough, then the prosecutor can say, I'm going to initiate an investigation. And this investigation can be challenged by the state. There is all sorts of protections in order to protect the sovereignty of each state altogether. So how can crimes be referred to the prosecutor, basically? There are three ways. First, by state parties to the Rome Statute. This is the lower left, Venezuela, Ukraine. The 6 states requested the prosecutor to open proceedings against events in Venezuela. Venezuela immediately reacted by asking the prosecutor to initiate its own proceedings against those 6 states. But that's procedure. And recently we had 43 states asking the prosecutor to open proceedings on the situation in Ukraine. Second possibility, the UN Security Council can refer situations to the court. It did twice with American support, once in Darfur with benevolent support from the Bush administration, and one in Libya with support from the Obama administration. And when it is a prosecutor that determines that there is crimes within the jurisdiction of the court that have to be prosecuted, he can do it, and he has to ask permission from the judges, which does not occur in the other cases. Now, I have skipped request by a state party, because this is the law of unintended consequences. The drafters of the Rome Statute had not envisaged the possibility that individual states would ask the court to investigate cases on their own territory on which they had normally full authority and which could be dealt with their own courts. But some states prefer to hand things over to the ICC because for many reasons altogether. And it turns out that for the prosecutors, this is the ideal situation, because if it's the states that asks the prosecutor to come in, there's no problem of cooperation. There's no problem of access to evidence. There's no problem of access to witnesses. There's no problem of arresting the potential suspects. The states cooperate. So all the trials that we have been looking into in the first 20 years of the court came so far from something which had not really been envisaged by the statute, self-referral. And the irony of the situation is that all those cases happened to be in Africa because they were African governments. The first one, the government of President Museveni in Uganda, that thought it was a good idea to hand over certain cases to the ICC, made them look good, and it allowed justice to move forward altogether. Very briefly, to give you a taste of how the whole thing operates. Prosecution, you have the picture here of our current prosecutor, Karim Khan. He is in a QC, now KC uniform, and he's the engine, and a very forceful engine as a personality of the court, because he's a guy who has the responsibility to make the strategic choices of where the prosecution is going to go, which situations are going to be investigated, which cases are going to be built. He has to be highly selective. The court is a small operation. We have only about 1,000 people in the court. He has only a few dozen investigators that he can deploy, and he has to make sure that whatever cases he puts together are going to make it with the judges. The judges are pesky guys. They will do their job, and they will not grant him on principle anything he asks. So he knows that he has to lead in critical cases which will be exemplary and which will, to the maximum extent, deter potential criminals. He is a gentleman who is currently on the ground in the situation in Ukraine and has been trying to put together teams. We will come back. Second group of stakeholders, I will skip some, but these I think deserve your attention. They are the 18 judges. Now, I think it's not the current composition because of COVID. We've never managed to get together the new team. The judges are elected for 9 years. Every 3 years, you have 6 new judges that come in and 6 that go away. But this is to give you a sense of the variety of the team. I will just give you the nationalities briefly. South Korea, Democratic Republic of Congo, Canada, UK, Uganda, Czech Republic, Germany, Benin, Nigeria, Trinidad and Tobago, Dominican Republic, France, Peru, Philippines, Japan, Hungary, Italy, Poland. Poland is the current president right now. I can assure you it's not simple to work in a multilateral framework with colleagues from such different backgrounds, but we manage altogether. It takes time, it takes dedication, understanding, patience, but that's the law of multilateral work, the multilateral diplomacy, which we shared with Katie, and it works among judges also. We operate in chambers of 3, so by majority, but we're allowed to have concurring and dissenting opinions. And there's an appeals chamber of 5 altogether. Trials are long. The whole sequence of trial, with first the pre-trial phase and the trial phase and the appeals, can last, unfortunately, up to 10 years. We had 2 accused which were acquitted from Ivory Coast, former President Gbagbo and Mr. Blegude, who spent 10 years before their acquittal and before they were sent home. That's a bit rough, but that's the conditions of fair justice altogether. In the end, they were acquitted. Now, there is, of course, a defense. The accused have counsel. Those counsel are paid for by the court. And I couldn't resist putting the picture of a nice representative of victims. This is Amal Clooney, who is apparently receives also some pro bono support from somebody in her family. So she always has a very, very strong team of lawyers supporting her altogether. But the defense and the victims have counsel, and the victims fully participate in the proceedings, which is an absolute first in international justice. The victims are represented. So the victims are not only witnesses, they are also a party to the processes. Now, if I can, give you just bare testimony, having the victims as witnesses is sometimes a very difficult moment for the whole chamber and for the whole hearing, because you have people who've been subjected to terrible crimes, who come from completely different cultures, very far away, and are really in a completely different planet when they find themselves in this international court with all sorts of strange people in front of them, but nevertheless have to retell their personal stories. And it's extremely wrenching and painful very often. And occasionally the judges have a hard time maintaining a proper procedure in the court because people break down, and there are very, very delicate moments. One last slide to give you a taste of the variety of situations where the prosecution is operating right now and trying to identify cases. So you have in Latin America, Venezuela, and Colombia. Colombia technically has been closed as a preliminary examination, but is still being very closely followed. You see in Africa a very broad group, Sudan, where the Darfur situation is, Libya, and where all the first cases were in Democratic Republic of Congo, Central African Republic, Mali, Ivory Coast, Guinea, potentially very soon Nigeria. We had a series of cases in Kenya, but of course one of the accused became president, so it cooled down a little bit. And then of course you have Afghanistan and the Bangladesh, which is really the Rohingya refugees from Myanmar, Philippines, and a little blue spot over there at Ukraine, which is, of course, we will come back to this, the object of great attention. So this is also to give you a sense of the extreme difficulty of the job of the prosecutor and afterwards of the judges. We have to get involved in circumstances and situations which have very difficult cultural context, massive crimes operated, lot of difficulty in getting the evidence and the witnesses, but nevertheless attempts to do the best possible job. So these are the cases we have to deal now. In pre-trial, two warlords from Central African Republic, which were arrested and which were sent over to The Hague. And at the trial stage, one from Mali, one from Darfur, one from Kenya. Actually, I should have taken him away because poor gentleman passed away, and two more from Central African Republic. This is just an illustration of the point I was making earlier. Because of the circumstances, the court started working with self-referrals, with cases handed over to it by African governments, with the exception of Darfur. Darfur is a United Nations Security Council referral, and Mr. Abderrahman, in fact, handed himself over. For many warlords, after a life spent in the jungle or in the desert, the prospect of going to the court is actually rather attractive. They can have 3 meals a day, free health care, they can get family visits, and they don't have to worry about being eliminated by their own crews overnight. So there was another one which has now been fully judged, Mr. Ntaganda, who handed himself over to the US consulate in Kigali one day because he was beginning to fear for his own life. So he's taken care of now. I'm not sure in which country, but he did get 25 years for what he had been doing. Now, everything I have been saying so far is really a preparation for dealing with, I'm pretty sure, the issue which is most on your mind. On this one, I have to be very careful because I might be, as a judge, involved at some stage. So there are a number of words that I'm not going to pronounce, but that you can sort of reinsert in my speech. So the ICC has been given jurisdiction on the situation in Ukraine actually 3 times. The government of Ukraine gave it jurisdictions for the first time on certain events in Ukraine in 2014. The government of Ukraine did it again in 2015 regarding events in Crimea and in the Donbass. And then, as I said, in March of this year, 43 nations asked the prosecutor to get involved in the situation in Ukraine regarding the most recent developments. So the prosecutor doesn't have any worry. He doesn't have to ask permission from the judges to initiate an investigation. He can send the judges tomorrow morning a request for arrest warrants whenever he feels he has identified people he can accuse and where he can put together a file that makes sense. The standard for an arrest warrant is not the highest one. It's not beyond reasonable doubt, which is the one for a decision or an appeals judgment. But still, the judges look very carefully before issuing altogether an arrest warrant. Now, of course, the Ukrainians themselves are also investigating very actively on the ground, and they intend to prosecute themselves major crimes which are being committed on their territory, which fall within the definition of the Rome Statute. So you might say, well, according to the principle of complementarity, which you have just mentioned, the ICC should have no role in pursuing those crimes. Well, not quite, because the Ukrainians would like the ICC to be involved also, among others. But there are also others, because there are countries which will use provisions of universal jurisdiction, which allows them to get involved in crimes committed outside of their borders, even by foreigners, who have also gotten into the effort of preparing for potential trials in Ukraine. Countries like Poland, Slovakia, and the Baltic countries are actively interviewing refugees, Ukrainian refugees on their territory and trying to put files. So there are several attempts to coordinate all this. One of them is a cooperation mechanism within the EU called Eurojust, which is, of course, based in The Hague, and which is a sort of clearinghouse among prosecutors who exchange information, evidence, and witness testimony. But the great challenge when you get into mass crimes like those which have been committed in Ukraine, the first thing you have to do is set up very sophisticated, powerful databases with specific IT, so that you can bring on board in a well-organized way everything you can gather, all the evidence which is being gathered on the ground, and order it, put it in a framework, and link it to potential culprits. That takes time. That takes enormous amount of resources and know-how. There is actually a mechanism which has been set up by the General Assembly of the UN to do this exactly for crimes committed in Syria. And they've been involved in this now for several years. But the first 2 years of their action was strictly related to IT. They had to set up the mechanisms they've been using. So far, the process of investigating crimes has been mainly handled by the Ukrainian authorities, with a number of technical assistance from foreign actors. There have been lots of teams from the Netherlands, from Sweden, from France, actually, on forensics on the ground, which have started to build up the database. The ICC is in the process of deploying its own investigators. It asked for extra resources from its participating states, so they were quite generous, providing extra personnel, but not huge numbers. They pledged 60 extra personnel and 15 million euros extra money. When you think about what the crimes committed in Ukraine may require over time in terms of the investment to really build up the cases and then prosecute them, it's only a very small beginning, because this is another one of the lessons which why I took the liberty to go over a historic process. International justice is slow, it is demanding, and it requires a continuous level of political support. In other words, the Ukrainian authorities will have to be very determined, and the countries and states which support them in this endeavor will have to be equally determined to continue. We are speaking about tens of years. Some of the arrest warrants we have right now in the ICC were issued 15 years ago. They still have not been fulfilled, but they still stand. So there are people who maybe will come to us. And lately, the MICT got somebody, a gentleman called Kabuga, who had been hiding in France, actually, after having committed atrocities in Rwanda. He's in his 90s, but nevertheless, a trial is being held against him. So patience, determination, and support, including back to the United States, the U.S. support, because altogether the U.S. has a lot of keys in the Ukraine situation because of its access to all sorts of technical tools which can be used in a trial. We take in international justice satellite photos, intercepts of telephone conversations, exchanges on mail, on social media. Social media is actually in Libya has been our main source, because some people like being filmed and doing very ugly things altogether. So all this is part of the process. But the U.S. is very much discreetly assisting, and it is present as an observer in Eurojust. So because of the number and nature, the gathering of the information of the crimes committed in Ukraine is going to require some coordination among the different stakeholders. The Ukrainians will have to decide what they want to do themselves, what they want the ICC to do, what they want to other tribunals to do. This is going to be a complicated discussion. It will rely upon how much each of the channels has available to itself. And of course, the big question you have in mind is who's going to go after the top of the pyramid of the. Now, I'm sure some of you may be aware there's been a proposal to create yet another new international tribunal, which would be dedicated entirely to investigate the facts of aggression against Ukraine. Quite obviously, you know where they might come from. I don't. But the issue of creating another tribunal is a rather complicated issue, because when you think about it, creating a tribunal, first, who are the nations that are going to get involved into setting up such a tribunal? A lot of nations take their distance towards what is happening in Ukraine, so it might be a much smaller group than the 124 states parties to the Rome Statute. It will require time, it will require resources, and it will further complicate the situation which I've been trying to describe to you in Ukraine, which is a rather complicated situation. The Ukrainians have not signed and ratified the Rome Statute. They have their own reasons for it. Perhaps the Ukrainian military have their own reasons for it altogether. So having another tribunal specifically for crimes of aggression may seem an extraordinarily generous and positive idea. In practice, a number of countries are not very strongly supporting it. To the extent of my knowledge, the United States has never manifested any support for the idea so far, which certainly does make a very big difference, because the US would be on the forefront if such an idea would be moving forward. So I've tried to give you a sort of broad picture, and what is hard, of course, to convey is my own personal experience in this. It is quite an adventure, quite a moral challenge to be involved in international justice, and this is why, in spite of the fact that we're all different judges, we're all different members of the court and prosecution, we have, I think, a very, very strong commitment to make this happen and move forward, and a sense of responsibility. But we also know that it's a work in progress. It's still very fragile. It's not given. It very much depends on the support of major nations, including the United States. And it can go forward, it can go backwards. There is no guarantee of success or of achievement. And this is what I wanted to share with you. Thank you very much.
No, please. Thank you so much, Ambassador. And we now have time for open questions, so raise your hand and I'll try to hit all parts of the room. Let's start with the gentleman back there in the back. Tom?
Enjoyed your presentation. It left me with a question, and that is with regard to Ukraine and the unspoken country of Russia. At what point in time does Russia or any country get involved in the process? Does it wait until the courts take the case and Russia is drawn in, or do they get involved earlier than that?
Well, let me not answer your question by answering it differently. You may have seen on the map there was a spot on Georgia. The prosecution asked the judges to allow it to investigate the situation in Georgia, and there I can name names following the summer war in 2008 when Russian forces invaded Georgia. So there has been a process in Georgia where there have been arrest warrants, against Russian citizens, and therefore the Russians have been requested to provide evidence, exculpatory evidence if they want, but they've not been kept out of the process. They've been informed, and the prosecution has talked to them. They, of course, have not responded and did not get involved in any way. Russia is not a signatory of the Rome Statute. It is, in fact, sorry, it was a signatory of the Rome Statute. The Russian negotiator signed with me on the 18th of July 1998, but then the signature of Russia was withdrawn. Don't remember the exact date, but a couple of years ago, I think. And therefore it is completely out of the process. So I suspect that the attitude they will have in comparable conditions, rebus sic stantibus, if you allow me, would be the same as the one they adopted in Georgia. Get out of it. Keep out of it.
Thank you.
Yes, sir.
Is the death penalty off the table in these cases?
It's not in the Rome Statute. We only can give lifetime prison, and we've never done it actually.
Yeah, where are they imprisoned? If you go to court and you sentence them, how you decide where they're going to be imprisoned?
Well, that's a very good question because we don't decide. It depends which state is willing to take them. Mr. Alassane, for instance, from Timbuktu, which I participated in. No, it's Al-Mahdi who Alassane is still on trial. It's Al-Mahdi. He's in Scotland, so the UK accepted to host him for his prison term. Others, some of them have gone back to their home country. When it is in some African countries, I'll make no comments, but there are adaptations, let's put it that way, in their conditions of detentions. Because it's the government that sends them, but the government may need them again in different conditions. So maybe their situation is not too bad.
Yes.
Yeah. Why is the ICC so slow when it comes to African countries where crime against humanity are committed tremendously, but the media, I mean, it was slow in Rwanda, and you didn't mention a word about Ethiopia, so that, that rings a bell.
Well, first, regarding Rwanda, it's not the ICC, it's the ICTY, and honestly, the ICTY was faster than the ICC. The ICTY had approximately, I think, 90 plus people indicted, and 60 were convicted, or 70 were convicted, so which was a pretty good rate, and they did it in about 4 or 5 years. International justice is slow by sense. You can't do otherwise, because putting together the case requires time, making sure that there's a due process and a fair process to the accused requires all sorts of guarantees that also require time. Now, of course, your question is why Africa? Because, well, as I mentioned to you, the only trials we've had so far were self-referrals from Africa. But I also made it pretty clear that whatever may come out of the situation in Ukraine is not likely to be very fast, because it will take time to provide the preparations and the guarantees for a full and fair trial. There will be great pressure to accelerate them, of course. We all recognize that, if only because the states are cheap and they don't want to give too much money. So judges will have to draw the consequences and conclusions from this.
Yes.
What is the extent of the court's jurisdiction in relation to crimes committed either against or by countries that are not involved in the court?
Well, the court has jurisdiction whenever the national of a state party to the Rome Statute has been involved, or whenever the crime has been committed on the territory of a national of a state parties. Let me be very clear, that means that American servicemen who operated in Afghanistan, which is a state party to the statute, potentially could fall within the jurisdiction of the court. I think the Office of the Prosecutor is aware of the complications that this might arise, to be very polite. But technically, right now, there is no jurisdiction on a third-party state, like, for instance, Russia. Only those citizens of a third-party state which commit a crime on the territory of a state party, or in case of Ukraine, the Ukraine gave jurisdiction to the court, Article 12a. So that means that potentially citizens of third parties which committed crimes on the territory of Ukraine can be prosecuted. I hope I was clear. I have to be careful, but. Or the Rohingya is a bit complicated because there the judges had to interpret, if I may say. 800,000 nationals of Myanmar were left Myanmar because of violence against them and prosecutions, and are currently 800,000 refugees in Bangladesh. and the prosecution considered that major crimes had been committed against them, but it was uncertain of the legal basis. So it went to the pretrial chamber and said, what is the degree of my jurisdiction over those people? And pretrial chamber said, one major crime, deportation, has been committed, which has a consequence on the territory of a state party, Bangladesh. So you have jurisdiction on those crimes. But it's a complicated situation, and the prosecution is having a hard time with it. But still, they are working on it.
Steve?
Could you touch on the meaning of the Hague invasion, to get around your courteous answer before, the meaning of the Hague invasion and how it's impacted the role of the United States in the ICC?
Well, for those who are not familiar, the Hague invasion, I think, is a nickname of an act of Congress which was adopted during the first Bush administration on the initiative of then National Security Advisor John Bolton, which wanted to be absolutely sure that if any U.S. citizen was prosecuted and arrested by the court, this would be unacceptable, and that all measures, excuse me if I don't have the exact wording in mind, all measures would be taken so that the court could not operate on those people. So, of course, this might have involved an invasion of the jail where arrested people are kept in The Hague. I don't know what the case so far has never happened. The other, since you're kind enough to raise it, I will mention it. The prosecutor of the ICC was under sanctions from the Trump administration for a fairly long period. Those sanctions were lifted by the Biden administration, but they were very severe sanctions which were taken. This is history now.
Yeah, how do you see the future of the ICC? I know 4 or 5 years ago, some African countries felt that they were particularly targeted by the ICC, and they started withdrawing. In fact, Burundi, I think, withdrew in 2017, then also the Philippines in 2019. So how do you see the future? Strengthening the ICC or becoming weaker?
You know, all international organizations are as strong as the support they get from their participating states. Regarding Africa, I'm sorry, I cannot follow you. I made it very clear. The reason that ICC got involved in Africa was on the request of the Africans and the African governments. So, of course, when things started getting a bit complicated for some African governments, they politically were clever enough to say, we're being targeted. But for some reason, this came largely from some Eastern African countries where it was in fact the prosecution who had taken the initiative, and where the then president didn't feel that comfortable. I will not use names, but you're probably familiar with that particular case. So regarding the rest, the sad reality is that major crimes are being committed on the surface of this earth every day on a massive scale. And that the justification for an instrument of justice, even if it's entirely symbolic, even if the chances that it will get involved in each individual crime are extremely small, is nevertheless there, because it's part of the spirit of justice, which is in all of us. We can't, within ourselves, accept the idea that there will be complete impunity for all those crimes. And even if it's a very imperfect institution, it's still an institution which has that purpose. I don't know, there will be ups and downs, how it will work. What I know is that the current situation in Ukraine has been a wake-up call for a whole group of countries who had taken a sort of attitude, well, the ICC is dealing with certain situations in Africa, that's okay, we can afford that sort of justice. No, not now. They have to take serious positions about whether they are going to be willing to support justice in Ukraine over a prolonged period at very substantial cost, politically as well as materially. you know what democracies are like. They have their ups and downs everywhere. Huh?
I just want to say that I agree with you. I think it's up to the leaders of several important countries like the US that should take the leadership to press for a stronger ICC.
Thank you very much. You've read my mind.
Yes.
When drawing up the requirements for like a warrant or something, where would they draw the line between like a commanding officer telling his soldiers to do X, Y, Z? Would the officer be responsible for the war crime, or would the soldiers under him?
That's a very excellent question. The command responsibility altogether. There's Article 28 of the Rome Statute deal with it, and basically says that you can identify a commander as responsible for acts which he has not personally committed, to the extent that he was aware, he did nothing to prevent those acts, and whether you can link the orders to him. One time when one of the chambers attempted to do this was against a Congolese warlord who was vice president at the time, called Mr. Bemba. And Mr. Bemba had sent his militias to the neighboring country, Central African Republic. And of course, they had massively misbehaved. So the court, enabled by the government of Central African Republic, went after Mr. Bemba. And the prosecutor had a very hard time proving that Mr. Bemba was fully aware of what his militias were doing. And Mr. Bemba had good lawyers. He said, well, you know, I gave strict instructions that they should behave well, and I was trying to behave. I sent a commission, and so on and so forth. And so Mr. Bemba was convicted by the trial chamber, but acquitted by my colleagues in the appeals chamber, because they thought that the command relationship had not been fully supported. So in the modes of liability, you have a whole gradation, like in any criminal law system, and a good prosecutor will try and find the best way to avoid getting too much involved in the command responsibility, because it's very complicated to bring proof of the links when you go upwards. Of course, some leaders say explicitly that they take responsibility. Once again, follow my thoughts.
Any additional questions? Yes.
If a charge of improper acting or whatever was brought up with someone within the court, would that be handled by the court or by your country of origin, by the UN? Or?
No, this is held by we have all management systems that basically, if it's a judge, it's run by the judges. If it's a staff, it's a different system. There are boards and so on. No, the really interesting cases is where counsels start misbehaving. We had a case where the counsels of one of the accused were extremely clever. They invented witnesses. They trained witnesses, which became defense witnesses. And after a certain time, the prosecutor found out that the counsels were actually orchestrating a very clever defense. This is called an Article 70 case. I was involved in one of them. It was actually, once again, Mr. Bemba, because Mr. Bemba had excellent lawyers who thought, well, let's make reality look a little more real. And he got on this, Mr. Bemba got convicted. And we actually put a fine on him. I was very proud that we did that, because he was the richest man in the DRC.